Somewhere in a Washington, D.C. federal records office, there are 2,487 pages, spread across 307 separate documents, sitting inside 4 different U.S. government departments, and every single one. His Royal Highness Prince Harry, the Duke of Sussex, or, as the court paperwork rather more bluntly puts it, Henry Charles Albert David. For 3 years now, a Washington, D.C. courtroom has been locked in battle over whether the American public gets to see exactly how Prince Harry obtained his visa to live in the United States. After court delays, after missed deadlines, after heavily redacted document dumps that told us almost nothing, and after one of the most suspiciously timed postponements in modern legal history, we are now heading straight for a July reckoning. Welcome to the Royal Crown Diaries. Today we are diving headfirst into the Prince Harry visa saga. What has already been revealed, what is still dangerously hidden, and why this extraordinary 3-year legal circus could be about to reach its most explosive chapter yet. Let us begin at the very beginning, January 2023, Sami Troy. Prince Harry, the Duke of Sussex, younger son of His Majesty King Charles III, publishes his memoir, Spare, and in it he writes, with what we might charitably call remarkable candour, about his past drug use: cocaine, cannabis, psychedelic mushrooms, ayahuasca. He recalled snorting cocaine starting at 17 years old. Of course I had been doing cocaine around this time, he wrote. At someone's country house during a shooting weekend, I'd been offered a line, and I'd done a few more since. He wrote about marijuana, describing smoking an entire shopping bag of weed, magic mushrooms in Los Angeles, ayahuasca as part of a healing journey. Now, here is where things get legally juicy. Under standard American immigration law, anyone applying for a visa must disclose past controlled substance use. Admitting to cocaine, cannabis, and psychedelics can be grounds for visa denial, or at minimum requires a rigorous waiver process that most ordinary applicants navigate in exhausting detail. So, a conservative think tank called the Heritage Foundation read Harry's memoir very carefully, looked at US immigration law even more carefully, and asked one very simple, very pointed question. Did Prince Harry tell the truth on his visa application, or did he get special treatment because he is a prince? And in 2023, they filed a Freedom of Information Act lawsuit against the US Department of Homeland Security. The case, Heritage Foundation versus DHS, was formally born. And it has been the most extraordinary, chaotic, legally maddening, and terrifying. Let us move through the key rounds, because, dear friends, there have been many. June 2023, the first federal court hearing in Washington, D.C. Heritage Foundation Director Niall Gardner declares publicly, Donald Trump is ushering in a new era of strict border control enforcement, and Prince Harry should be held fully to account as he has admitted to extensive illegal drug use. The government fires back immediately. In a letter dated June 2023, DHS Senior Director Jimmy Wolfrey writes, to the extent records exist, this office does not find a public interest in disclosure sufficient to override the subject's privacy interests. Translation: not your business. September 2024. Judge Carl Nichols, a Trump-appointed federal judge, rules that the public does not have a strong interest in seeing Harry's records. A provisional win for Harry's privacy. Heritage Foundation's chief counsel Kyle Brosnan is furious. He tells Newsweek, Prince Harry repeatedly admitted to using illegal drugs in his memoir. This fact alone makes him inadmissible to the United States, but the case does not die. Heritage appeals immediately. February 2025. Judge Nichols reverses his own earlier decision. He orders the documents released with appropriate redactions. March 18th, 2025. The big day finally arrives. Over 80 pages of court filings and transcripts are made public. And the documents reveal almost nothing. Massive sections blacked out in solid ink. Entire paragraphs invisible. DHS official Jared Panter writes in the heavily redacted filing, this speculation by plaintiffs does not point to any evidence of government misconduct. The records show the regulatory process involved in reviewing and granting immigration benefits, done in compliance with the Immigration and Nationality Act. The Heritage Foundation is incandescent because here is the devastating detail. The documents released were not Harry's actual visa application. They were documents about the process, procedural papers, administrative records. Harry's actual immigration forms, the ones that would definitively answer whether he disclosed his drug use, remain completely hidden behind privacy protections. August 2025. The plot thickens dramatically. New court records reveal the Department of State is sitting on 1,007 separate documents related to Harry's case. Breaking that down, 217 documents in the Office of the Secretary of State, 517 potentially responsive records in the Bureau of Consular Affairs. Heritage's attorney, Samuel Dewey, tells reporters, with barely concealed astonishment, the number of papers on Harry shows they are monitoring him pretty closely. 1,007 documents for one visa application. Even Harry's most devoted fans must concede. That is a lot of paperwork. And now, dear friends, we arrive at the part of this story that has set the royal commentary world ablaze. April 13th, 2026. A new court filing reveals the State Department has identified 307 separate records totaling 2,487 pages potentially relevant to Harry's case. The bureaucratic breakdown is almost comical in scale. 517 documents from the Bureau of Consular Affairs, 217 from the Office of the Secretary of State, 271 from the Office of the Legal Advisor, and we are absolutely not making this up. 2 more documents sitting on the Deputy Secretary of State's own personal desk. Officials miss their March deadline entirely. Their excuse? Purely bureaucratic factors. Too much paperwork, too many departments, too complicated. But here is where the Heritage Foundation explodes. The new court deadline gets pushed to June 12th, 2026. And what else happens between April and June 2026? King Charles III's state visit to America, scheduled for April 27th to 30th. Complete with a White House state dinner, the King and Queen hosted in Washington at the very highest levels of diplomatic protocol. Mike Howell, Executive Director of Heritage's Oversight Project, does not hesitate for 1 second. He publicly accuses the US government of engineering a delay to prevent damaging revelations from overshadowing King Charles's visit. He calls it an esarisiridí, explicitly a cover-up. Now, to be completely fair, the court filing itself does not formally link the delay to the royal visit. The government describes the missed deadline as purely bureaucratic. But Niall Gardiner, Heritage's director, states publicly, Americans deserve to know if the rules were applied fairly to a high-profile immigrant. And the timing, dear friends, the timing is, shall we say, remarkably convenient. Now, let us explain the central mystery at the heart of this entire saga. The Heritage Foundation wants to know one fundamental thing. Which visa did Prince Harry actually use to enter the United States in 2020? There are two possibilities, and they could not be more different in their implications. An O1 visa, reserved for individuals of extraordinary ability, requires a sponsor, requires documentation of achievements, and, crucially, requires the applicant to go through standard background checks and disclose all past drug use. Or an A1 visa, reserved for royals, for government officials, for heads of state and their families. An A1 visa holder moves through the system in an entirely different category, one that, Heritage argues, could have allowed Harry to bypass the very drug use questions that apply to any ordinary person. DHS attorney John Bardo has spent 3 years arguing that revealing even which type of visa Harry holds would be an unwarranted invasion of privacy that would subject him to reasonably foreseeable harm in the form of harassment. Heritage says that argument is nonsense, that the type of visa is a matter of public record in any normal case, and the only reason to hide it here is because the answer is embarrassing. If Harry holds an A1 visa, it could mean he never had to answer the drug questions at all. If he holds an O1 visa, it means he either disclosed his drug use and received a waiver, or he did not disclose it, which Heritage's Samuel Dewey has stated publicly could constitute grounds for deportation. People are routinely deported for lying on immigration forms, Dewey stated flatly. Routinely deported. Those are the stakes this case is playing for. And so we arrive at June 12, 2026, the latest court milestone. GB News confirmed this week that an update in the ongoing legal battle is imminent. The case remains very much alive and very much unresolved. And now, the next milestone is expected in July. With 2,487 pages under active judicial review across 4 government departments, Judge Nichols must work through, record by record, what can be released and what stays sealed. So, if a meaningful release happens in July, it could for the first time publicly confirm, 1. Exactly what type of visa Harry holds, O1 or A1. 2. Whether he was asked to disclose drug use and what he said. 3. Whether any waiver, exception, or special accommodation was ever granted. And if the answer to any of those goes the wrong way for Harry, the consequences could range from deeply embarrassing to, in the most extreme scenario Heritage has consistently pushed, a genuine legal challenge to his ability to remain in America. Now, to be completely fair, once more, DHS has consistently maintained that Harry received no favourable treatment whatsoever. Judge Nichols himself previously wrote that, like any foreign national, the Duke has a legitimate privacy interest in his immigration status. So this could also simply fizzle. Another batch of heavily redacted papers, another frustrated Heritage headline, another chapter where the actual core documents remain sealed forever. But dear friends, after 3 years, over 1,000 documents, and a saga with more twists than anyone anticipated, we would not stake much on it being boring. And we cannot tell this story without addressing the extraordinary presence of President Donald Trump looming over the entire case. Because Trump's position on Harry has been evolving. During his first term, Trump was withering about Harry and Meghan. He said publicly he would not pay for their security if they moved to the US. He was far from welcoming. When the Heritage Foundation's case gathered momentum under his second administration, many assumed Trump would order the records released immediately. But instead, he softened. In an interview with the New York Post, Trump stated, "I'll leave him alone. I don't want to do that. He's got enough problems with his wife." The deportation talk went notably quiet. Heritage's own Niall Gardner publicly urged Trump to intervene, telling journalists the president does have that legal authority to order the records released directly. Trump has not done so. And that silence, dear friends, is in itself quite extraordinary. A president who has made immigration enforcement his defining issue, going quiet on a case involving a foreign national who admitted in a best-selling memoir to years of drug use. A duke, living in Montecito, California, with Meghan, Archie, and Lilibet. While 3,000 miles away in a Washington courtroom, lawyers fight over thousands of pages that could determine his entire future in the country he now calls home.